welcome everyone to the last seminar before the meeting week, and I appreciate those who are here in person. I know some other people are attending online, and so I'm very happy to introduce today Sophie Nunnelley, who is an Associate Director of the University of Ottawa Centre for Health Law, Policy and Ethics, a Senior Research Associate on the CIHR-funded project Machine MD, How Should We Regulate AI in Healthcare? She's also a doctoral student in the Faculty of Law here at the University of Toronto, but soon to be full doctoral person, because she just submitted her dissertation and has a defense in a couple of weeks. And we received actually yesterday the external report, so we'll be happy to see that going forward. Sophie writes on issues of health and disability law, human rights law, law and artificial intelligence, and legal theory. She's a former Vanier Scholar, Lupina Fellow in Comparative Health and Society, CIHR Fellow in Health Law, Ethics and Policy, and a Fulbright Scholar. She previously practiced law, which you see reflected also in her work, most recently with the Constitutional Law Branch of the Ministry of the Attorney General for Ontario. Sophie holds law degrees from Yale, University of Toronto, and was a law clerk to the Honorable Mr. Justice Charles Gontier of the Supreme Court of Canada. So with that in the background, she has written a very interesting chapter that most of you read on autonomy, the concept of autonomy, and coercive mental health care. So Sophie, I will let you present. I have students who submitted, as usual, in our format questions to me, and I will invite them to start the question period, but other people will come in, and I will check on the chat box also if other people who are online want to participate with specific questions, and we'll try to address some of these. Sophie.
Great. Thank you very much, Trudeau, for the invitation and the introduction. Really happy to be here. Thank you all for coming. I'm just going to start by saying I wish to acknowledge the land on which the University of Toronto Faculty of Law operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit River. And today, this meeting place is still home to many Indigenous peoples from across Turtle Island, and I'm grateful to have the opportunity to work on this land. So I'm going to just share my screen here, and hopefully all this goes smoothly. Is that working? All good. The remote's not working. Okay.
It's always.
Professor, do you want me to run and see if I can get an IT person?
That would be great.
Yeah, that would be great. Yeah, let's try to solve this first.
Sorry, everyone, a little bit of technical difficulty. Okay, it's just not advancing.
Yeah.
Oh, like I said, I just clicked the screen. If it's not responding immediately,
You just press on the screen.
Yeah, just
Okay.
click anywhere on the PowerPoint.
Okay, thank you very much. All right, so hello everyone. Today I'm going to be talking about healthcare decision-making rights. We all know that decision-making expresses our autonomy in big matters and small matters. We tend to really value the ability to express our autonomy through small and big decisions, and not just because we value having input in the outcome, but we value the very process of directing our own lives. And in medical decisions, especially, we tend to think about this right as really, really fundamental and sacrosanct and really a matter of human rights. Yet we're at a moment in history when our ideas about who should get to decide for themselves, who shouldn't, are very much in flux. We don't agree on when, if ever, another person should be able to step in and decide for a person for their own good. And at the core of this is really a more fundamental problem that transcends any particular decision-making law, and that's how do we adequately care for each other in our inevitable moments of vulnerability when we might have diminished decision-making abilities while also respecting rights. So narrowly, I'm talking about statutes, decision-making laws like capacity laws and mental health acts. But more broadly, it navigates very contested questions about what autonomy means, what care means, and whether those are compatible or incompatible concepts. And as I'll get to, the conventional discourse really likes to say that those are in tension, that we can't have both. And I will challenge that framing. So I just want to emphasize these are issues that apply to everyone. They'll apply to children, to older adults with impairments like dementia, to some people with cognitive impairments, psychosocial disabilities, especially when there's a psychiatric label, and so on. And it might arise in little matters like consenting to antibiotics for an infection or to very significant and irrevocable ones like medical assistance in dying. So of course, I'm not going to cover the waterfront today. I'm going to speak of one particular context that I think is especially contested and especially a site of discrimination historically and arguably still now. And that is mental health decision-making rights. And here I'm talking about a concept that I'm calling coercive care. And by that, I mean decisions that are taken contrary to a person's wishes for the purpose of their own quote, best interest care. And that's an important specification. There are mental health laws that use coercion for other purposes, most notably for quote, danger prevention. That's the language that's usually used to prevent serious harm to self or others. That's a whole other conversation, and there's a lot of controversy there as well, but it's not the conversation we're having today. I'm talking about involuntary hospitalization and admission and treatment when it's done for a person's purported best interests. And so my core claim is that answering this question requires looking closely at autonomy, and what kinds of autonomy are elevated in current law and what kinds of autonomy we could or should be promoting. It might seem obvious that decision-making rights involve autonomy. The problem is that we see autonomy language used all the time in really inconsistent ways, and I think sometimes in quite superficial ways. And so I argue for a real drilling down to investigate both the competing approaches to autonomy and also to ask the normative question about what we think autonomy could or should mean and how that might guide mental health law reform. Can you see this, or do we need to dim lights? Is it visible?
It's pretty good.
Yeah, okay. So I'm going to talk today about, I'm going to make comments in three broad sort of sections. First, I'll talk about why this requires an autonomy lens. Second, I'll talk about what this lens I think reveals about some current approaches in Canadian law. And then I'll talk about what I think some of the implications of a relational autonomy approach might be. Why do we need an autonomy lens? Well, most simply, there is a lot of, well, our mental health laws are paternalistic. There's a lot of coercion in our mental health law in Canada. And I think that's worth highlighting. There's quite a lot of contradiction in mental health policy trends. On the one hand, there is, I think, increasing recognition of the need for a lot of high quality supports. We speak of things like a recovery approach to mental health care that emphasizes empowerment. And there's some new funding flowing to these kinds of supports. But on the other hand, it remains the case that Canadian mental health law is centered around those twin powers of involuntary admission and treatment. And in fact, in some cases, reliance on coercion seems to be increasing and not decreasing. For instance, involuntary hospitalizations under the British Columbia Mental Health Act reportedly increased by 71% between the 2005-6 year and 2016-17. So that's quite a remarkable increase in the use of those powers. Now, the ordinary principles governing paternalism are autonomy. We don't normally interfere with autonomous self-governing decisions, even if they seem foolish, unless they're harming others. This is a very well-established principle in liberal political theory. The basic premise is that people are, quote, autonomous agents pursuing their theories of the good. And the theory goes, this allows for value plurality. So as I say, we don't interfere with autonomous self-regarding decisions. And while there's much to critique in that framework, I do think that the basic premise that autonomy is at the root of paternalism is sound. We can't act paternalistically contrary to a person's expressed wishes unless we think they lack autonomy in some legally relevant way. All of those terms have contested meaning, but that's the basic premise. And we see this at work in law. So judicial decisions about the right to medical self-determination really highlight that we have a right enshrined both in the common law and under Section 7 of the Charter to consent to or refuse medical treatment. This is true even if the decision will lead to harm or even death, for instance, the refusal of life-saving blood transfusion. And this is really, as I said, the courts consider it to be a bedrock charter protected right. And yet it also allows for paternalist intrusion where there's a finding of incapacity. So here capacity is the measure of autonomy. It's how our law typically measures, operationalize that concept of autonomy. Capacity law can look, capacity law can take many forms. It's not an objective standard. It's not something that we find, that medical professionals can assign in some objective way. It's a socio-legal standard. There have been many capacity standards expressed throughout history, and still now there are many different standards. But in Canada, the usual approach is a cognitive functional approach, and that means we look to a person's understanding of information relevant to a decision and their appreciation of the consequences of that decision or lack of decision. So that's the ordinary framework. It's fairly uncontroversial in some contexts. Now, what about mental health law? So the problem is that, or what I think the problem is, that these principles tend to go out the window when we talk about mental health law. Law typically, not typically, but very often does not govern mental health decision-making rights. And I think looking closely at autonomy can help us evaluate these moves and understand whether they're legitimate. And as I say, it also provides an opportunity to look deeper and consider what some of the alternative approaches might be. So this brings me to the second sort of section of my comments, which is what are the kinds of autonomy that are expressed in Canadian mental health laws. Every province and territory in Canada has a statute that allows for involuntary admission and treatment. Those standards are very different across the country. I think that already bears mention. Our rights are very different depending on where we live. So I'm going to look a little bit at what I think the autonomy thresholds are for each of three different kinds of laws and why I think each of them are somewhat problematic. So a first kind is autonomy as health. This is a category of laws that treats disability status as dispositive of decision-making rights. Now, this approach bypasses any functional approach to or assessment of capacity or autonomy. And in practice, the way it usually looks is a statute that allows for admission and treatment based on mental disorder. That's a defined term, usually in the legislation, and some degree of risk that's often articulated as substantial mental deterioration. And this kind of mental disorder plus risk law is very common around the world. In Canada, the only jurisdiction that expresses the full version of this is British Columbia. In BC, a person can be involuntarily admitted based on mental disorder that requires treatment to prevent the person's substantial mental or physical deterioration. And once they're admitted, they can be treated involuntarily. And this is so irrespective of capable refusal. The law under the BC Mental Health Act deems all involuntary patients to have consented to treatment. Now, to be clear, the idea of deemed consent is a legal fiction. It really turns the idea of consent on its head. There is no such thing as deemed consent. But that is the law in BC. It's worth noting that it's the basis of a current constitutional challenge that hasn't yet been decided on the merits. It went all the way to the Supreme Court on standing, and it's now needs to be decided back in the BC courts. But for now, this law stands, and the approach of authorizing care, coercive care, over capable refusal is also evident to some extent in Alberta, Prince Edward Island, and the Northwest Territories. There's some right to capable refusal, but a tribunal can override that refusal based solely on best interest grounds. So I think to some extent, those belong in the same category as BC. So what is the approach to autonomy here? I think it's fairly clear that one of two things is happening. Either autonomy is being ignored. There is simply a decision to prioritize care for one group of people deemed to have a mental disorder. And that I think is fairly clearly illegitimate, conceptually incoherent. As we said, we have to go through autonomy to get to legitimate paternalism. Or there's just an assumption that mental health status is a proxy for non-autonomy. And that also is extremely problematic. There's ample research, for example, establishing that diagnosis with a mental illness is a really poor proxy for decision-making ability. So either way, this kind of law that proceeds on this basis, I think, is illegitimate. It lacks an autonomy basis for paternalism and ought to be rejected. Second kind of law is civil libertarian. Now, these laws sit at the other end of the spectrum. They, I'm going to deal with them very briefly, but in short, they don't contemplate coercive care as an end of the law. Instead, they make danger prevention the only objective of mental health law in those jurisdictions. Quebec, New Brunswick, Yukon, and the Nunavut each have mental health legislation that lies at this end of the spectrum. Yep. Oh, okay. Technical interruption.
Just another quick note, is it possible to bring the speaker toolbar to the bottom, just so we can see the title?
I'm sorry, the what?
Just the toolbar, the Zoom toolbar from the top to the bottom.
Are you able to do that?
Sorry, the Zoom toolbar from the top to the bottom.
Let's bring this down.
Yeah, exactly. Perfect, thank you.
I think I'll carry on as this is.
If it's too complicated, no, it should be working.
I'm just going to carry on here while this is happening. My point here is just that these provinces use non-intervention as the sort of version of autonomy. So an example, I think, is Quebec. Its law is called an act respecting the protection of persons whose mental state presents a danger to themselves or to others. And the Quebec Court of Appeal has described the purpose of that law in terms of privileging liberty. It says the policy of the law is to privilege liberty. Institutional confinement is not a measure for social welfare. It's an exceptional measure to respond to a crisis in which there's compelling evidence that a person represents a clear danger to himself or others. So operating value here, I would suggest, is not autonomy at all, but rather negative liberty, non-intervention. And to be clear, a policy of non-intervention might very well be consistent with an autonomy framework if it were part of a broader plan for ensuring different and voluntary services and care. But I don't think that's the situation here. My understanding is Quebec, like the rest of Canada, is struggling with inadequate funding and services for folks with mental health challenges. So I would suggest that this simple policy of non-intervention without more is not rooted in a meaningful idea of autonomy. There we go. Okay, so a third kind of law in Canada is the provinces and the provinces that use legal capacity as the basis for paternalism. So I'm calling this autonomy as cognitive functional ability. Now, recall this is the standard that applies in other healthcare, and 5 Canadian jurisdictions apply this as well in mental health care: Saskatchewan, Manitoba, Ontario, Nova Scotia, and Newfoundland and Labrador. I'll use Ontario as the example. Capacity and informed consent to mental health care is governed by the general legislation in Ontario, the Healthcare Consent Act. And the Act states that there is no treatment without capable consent. There's a presumption of capacity, and capacity has to be assessed in a time and decision in a specific way. And then it sets out a test for capacity, that is that understanding and appreciation test that I mentioned earlier. So just very briefly, is this a plausible theory of autonomy? I think the answer is yes. It is the idea that autonomy is rooted in an idea of cognitive ability has a long history in liberal theory. It is at least a plausible theory of what makes us autonomous. As I'll get to, I think it can and should be critiqued, but at least it's conceptually coherent as a path to paternalism. And so in that way, it's better than the other two. This is not to say that capacity gets a pass. There are some significant problems with the legal capacity paradigm, and I can't do justice to that subject here. It's an enormous subject, but I'll just reference two, sort of broadly reference 2 issues that I think should give us pause. One is that legal capacity is bound up with quite a long history of exclusion. Persons with persons with disabilities very often are excluded from frameworks described by liberal theorists. So scholar Uday Mehta puts this in terms of liberalism's anthropological minimum, and he talks about how scholars from Locke to Rawls all envision the society of rational beings moving about, being in the original position, creating and being the subject of rights, and how these frameworks often either implicitly or explicitly exclude people with disabilities. And he's certainly not the only scholar to make this observation. There's quite a large literature talking about the problematic exclusion of people with disabilities and cognitive disabilities specifically from liberal theory. So I just want to flag that, because there is, I think, a valid argument that, or suggestion that perhaps capacity is part of this history. And the argument here would be that it's sort of the way, it's the tool for liberal exclusion. And I think sometimes we do see that that marrying of liberal exclusion with capacity. I came across a quote from one American legal scholar, Robert Schopp, who talks about mental health law. He's arguing for a version of mental health law that employs capacity. And he says, persons qualify for equal standing in the political domain by possessing at least a minimum set of psychological capacities that enables them to participate in the political process. He says, self-determination and equality converge. And I think this kind of statement suggesting that we need certain psychological capacities to be considered equal is not uncommon, but should be enormously troubling. And at the very least should give us some pause as we consider how to address legal capacity. So I don't know if that's clear. It's a very high level discussion, but we can come back to it if you like. The other reason why we perhaps should worry a little bit about legal capacity thresholds is that they seemingly elevate a form of decision making that doesn't really align with how we make decisions. It's a kind of rational, the idea of pure reason individually applied isn't really, it's a bit mythical. Louis Charlin wrote about this quite a lot, about how we tend to think of people as cognizers. He likened it to Spock, as though Spock is the ideal, from Star Trek, the ideal decision maker. So there's some problems there also. So, okay, if there are problems, autonomy related problems with the current approaches, where does that leave us? I'm going to spend the remainder of my time just to talk about where we might go from here and what some of the implications of a relational theory of autonomy might mean for policy reform. So far, we've seen the slippery nature of autonomy. And it's worth noting that proponents of each of those three approaches I talked about earlier all use autonomy language. They all say this approach is autonomy promoting. And yet I think we've seen that autonomy, when we drill down, is either health as defined by clinicians, or it's liberty, or it's individual rationality, and all of those are somewhat flawed accounts. So what could we do instead? Relational autonomy is one of those terms, like autonomy generally, that has many, many definitions. Susan Sherwin and Katie Stockdale refer to it as an umbrella term that includes any approach to ethical questions explicitly attentive to the relational nature of selves, that is, to persons who exist and develop within a web of relationships. And there are two positions at the heart of most relational autonomy theories. One is that autonomy is not independence. We all exist, develop, act within a range of relationships, including the personal with friends, family, neighbors, institutions, hospitals, schools, governments, within group and cultural relations, for instance, involving systems of privilege or disadvantage, racism, prejudice, and so on. And also that our autonomy is continuously formed. It doesn't get sort of influenced into some static form, but it's constantly ebbing and flowing. We exercise our autonomy through our relations. And I think this is very important because often, important for many reasons, but one of them is that when we pretend that autonomy is independence, it often ends up submerging relations and often relations of privilege that support those who are said to be acting autonomously or independently. And a second, a second basic premise that underlies a lot of relational theory is the idea that autonomy is not just reason. There are all kinds of other faculties that we employ in meaningful decision making, including emotion, introspection, imagination, and interpersonal exchange, and that these ought to be part of any kind of meaningful approach to autonomous decision making. So the two things are relations with others are part of what comprise our autonomy, and second, this autonomy can draw on a range of capacities and faculties, not just the rational. What does that mean, or what could that mean for law? as with, again, autonomy theory generally, it could be said to mean lots of things. And in fact, people do draw on autonomy theory to justify quite different approaches that are significantly in conflict with one another. So I'm going to conclude with just some comments about what I think it means for law. And I don't claim that relational autonomy can give us all the answers or any kind of detailed prescription for law reform. But I do think it offers some guidance. It resets the theoretical framework in ways that I think are important. So what are these ways? First, it tells us there's no inherent conflict between autonomy and care. And this idea of an autonomy care conflict is really, really deeply embedded in the law of paternalism and in Canadian health law. And I think that's an important point. It sounds very abstract, but people talk all the time about mental health law in terms of a need to balance autonomy and care, like we really need to decide which of these we're going to elevate at any given moment and for any given community or person. And a relational approach challenges this. It says, we have to recognize that we're all enmeshed in relations, including with the state. So first of all, the idea of autonomy as independence is incoherent. We're not looking to create some sphere where we can be left alone. And on the care side of it as well, it's not something, Beverly Cloud does this well. She says it's the state, sorry, not Beverly Cloud. Marion Barnes says the care is not exceptional, but rather a practice deeply embedded in everyday life. And recognizing those two features, the relational and continuum nature of autonomy, the nature of care, sort of dissolves the binary that capacity law normally puts us in. Normally, the law sort of wants to divide us in two, both an individual person in two and communities in two, those who are capable and rational and deserving independence, and those who need care and paternalism but don't have rights. Relational autonomy puts the lie to that and says we ought to be pursuing autonomy, respectful care. So in practice, what could that mean? I think it could mean many things. It means, I think, that moment of capacity assessment becomes less important, that we're looking at how to foster autonomy and wellness throughout the spectrum and for everyone, because we all lie somewhere on this autonomy spectrum. So it could mean more robust and more meaningful attention to social determinants of health. It could mean looking more at voluntary supports that people can access before crisis. Before getting to a point of crisis, we don't put all our resources into hospital care. And it means that when we do engage with law, when there is perhaps a capacity assessment, autonomy promotion remains important. We don't flip that person into a new category of an object of paternalism. They remain someone with some degree of autonomy, like all of us, that requires respect under the law. So that could mean, for instance, requiring that the person who is either the substitute or supported decision maker is chosen by the person. It could mean a legal requirement that they apply the values of the person. It could mean all kinds of things. It could mean a support, having supports for a social network building in advance of crisis. There are lots of creative ways that we could pursue this autonomy care convergence. A more concrete implication, which is really an example of that first point, is that we could pursue supported decision-making laws. A really exciting development that is emerging internationally is the development of tools that allow people to choose supporters who will help them develop and express and implement decisions. These already exist in Canada, including in British Columbia. In fact, British Columbia has one of the most innovative supported decision-making laws in Canada and has been looked to internationally. But the approach is still relatively infrequently used, and especially in mental health law. So recall that BC also has a problematic mental health law. it doesn't extend these supported decision-making tools to people under mental health acts. So there's, these two silos operating. And so I think a relational autonomy approach really calls for a bridging of these two areas and more meaningful extension of these kinds of tools to people who have mental health issues. So the last point I'm going to make here is that I think relational autonomy also highlights the ongoing need to consider and respond to moments of diminished autonomy. So again, I'm going to reference to an issue that's quite a large issue that I can't do justice to here, but the UN Convention on the Rights of Persons with Disabilities, the CRPD, is really important to this area of the law, and it calls for a paradigm shift in thinking about disability and rights. Now, lots of exciting developments happening here. Most relevant for us today is Article 12, which requires that persons with disabilities enjoy legal capacity on an equal basis with others. And what that means is a matter of debate, but the committee that interprets the CRPD has said that it means that legal capacity is a universal attribute inherent in all persons by virtue of their humanity. So this would mean no more legal capacity tests or thresholds at all. On this view, the role of the state is only to support people's will and preferences. And so is this the answer? Is this the relational autonomy promoting approach? Well, I admit I struggle a little with this question in the place for capacity in an equality respecting paradigm. I think at the very least, the CRPD is a needed jolt to the system. Peter Bartlett rightly says the notion that we should start with the individual and what he or she wants is an important reorientation of our mindset. He describes it as an attempt to hit the reset button. But I also think an autonomy lens helps us to evaluate this approach also. And on the face of it, I think this fourth approach effectively equates autonomy with agency. And autonomy and agency are closely intertwined. Agency often expresses our autonomy, and acts of agency often help us to develop autonomy through trial and error and that sort of thing, but they're not equivalent. And I think this is in fact acknowledged in a lot of the literature. There is this engagement with this puzzle right now as to when agency really is promoting autonomy and when isn't it. And so we see scholars like Flynn and Arnstein-Herslake, who are two scholars who make very thoughtful arguments for universal capacity, also say, well, yes, we have to promote will and preferences, but sometimes in exceptional cases, for example, if a person is contemplating serious self-harm, whether it's a person's true will and preferences. So, my thinking here is, okay, well, even if these are seldom used exceptions, these kinds of statements seem to acknowledge that core puzzle. How do we know when a given statement of preference is sufficiently authentic and when isn't it? And this is the same puzzle that capacity law is intended to address. So my suggestion here isn't that we ought to necessarily accept capacity law in its current form, but I'm struck that there really is no way around these autonomy puzzles. And if capacity law were to be abolished, it would have to be replaced by a suitably nuanced and careful law that was able to identify and respond to those moments we all have when we have some degree of diminished autonomy. So my comments today aren't meant to be, as I say, a very detailed prescription for law reform. It's more of a framework. I'm arguing for a rerouting of the discussion in autonomy. I think that we use autonomy in superficial ways all the time, but it's rarely acknowledged or rarely investigated in a deep enough way. We've seen autonomy as health, autonomy as liberty, autonomy as rational cognition, and then autonomy as agency. And I think investigating those meanings really allows us to see where are the contradictions within and across law. And this is important where we see what I said earlier, this real contradiction in current law and in mental health trends, mental health law trends, which is the increasing recognition of the overuse of coercion on the one hand, but then also continued and sometimes increasing use of ordinary conventional tools of coercion on the other. And so how do we bridge those conversations? I think autonomy helps us to at least make sense of them. And ideally, looking at a revised form, a relational form of autonomy, gives us some clues as to where we might go from here. So that's it. Those are my comments for today. Thank you. If you have any questions, please. I'm going to unshare.
Thank you very much, Sophie, and apologies for the interruptions while you were speaking, but we wanted to see if there were any questions also online. So if people online can post questions, I will see them here on my screen. We'll start with some of the questions from the room. So if I can invite some of the students to post their questions first. So Vita, do you want to take the lead in this?
Sorry, let me grab it. My apologies. My question related to more kind of the consequences of what you're proposing. So considering your perspective on the pitfalls of kind of this binary capacity approach, how would a non-binary approach to capacity be effective in the day-to-day work of healthcare professionals, considering their ethical and legal obligations? So in other words, how would it be captured, assessed, tested, or validated by those kind of boots on the ground in hospitals or other care settings who face professional liability, negligence, all of those types of risks as the healthcare professionals?
Yeah, that's a really good and important question. And I don't know if I'm going to have a satisfying answer for you, but I think at a broad level, what I'm suggesting is capacity and autonomy are related, but they're not the same thing. So whether or not we keep a capacity threshold, whether or not that's employed in a binary way, autonomy doesn't have to be binary. So I guess there are two parts to my answer. One is putting capacity law to the side, we can always consider how to promote autonomy, whatever a person's assigned legal capacity. So we should reject that move of saying, well, you've been declared incapable, you're this object of paternalism, and you no longer, the BC approach is the most stark example of that. There's no consideration of the person's values or wishes as soon as that entry into the paternalistic category happens. So there are lots of different possible entry points for autonomy considerations, I think, even in current law, respect for prior capable wishes, having the principles, every substitute decision maker has a list of considerations set out in law that they have to apply. So those considerations could be geared around respecting the person's autonomy. There also could be supported decision-making paths in there. So we needn't move directly to substitute decision-making. There might be a supported decision-making tool, and that's been explored in a bunch of jurisdictions around the world. I also think that capacity law itself could be revised so that we could alter the standards that are that understanding and appreciation, those criteria, to make them a little bit more nuanced and more attuned to a person's, the way to incorporate emotion, for example. We can also consider that capacity can be supported. There's such thing as supported capacity. So I'm giving you a bit of a grab bag of answers because I don't think there's one answer, but that's sort of the kind of framework I think about.
Thank you so much.
Mina, I mean, it's related to the question. Would you say it's answered, or you want to feel free to ask your question again? And
Okay, sure. So my question is also related to assessment. So your chapter talked about the Starson case as one that illustrates how reasonable people can disagree about the considerations that are relevant for understanding the autonomy of the person and how that relates to legal capacity. So I kind of had a two-part question. The first is, if legal capacity continues to be based on an understanding of autonomy based on rationality, what can be done to introduce greater certainty into the determinations of autonomy? And then the second part.
Certainty? Is that what you said?
Yeah.
Okay.
And then the second part is, if there's a shift towards considerations of relational autonomy rather than rational autonomy, do you think that would introduce greater or less certainty into assessments of class?
It's interesting because I think that part of the problem is that we like to pretend that capacity provides some certainty. It's enormously imprecise and very much something that is going to inevitably, I think, incorporate the assessor's own values. So I'm not sure that certainty should be our objective because it's illusory. I don't think there is, I don't think it's possible. I think maybe a better approach is to acknowledge from the outset that this is not a scientific exercise, and that maybe a more transparent discussion about how, and training perhaps for assessors to identify the values they bring to the table, the way in which, because a relational approach also can apply to the process of assessment. So that interchange between the assessor and the person being assessed is a relational process that very much will influence the outcome. You know, the tempo of the conversation, the kind of language used, whether they like each other, there's a lot that's going to go on there. And so I think that if we do keep some process, I think the best we can do is to kind of try to bring those values out into the open and talk honestly about them.
Emily?
I had very similar questions that were kind of addressed, but my concern was also in the practical component of relational autonomy. So, you know, if you're blurring kind of the binary nature of legal capacity in the law, we like to think of things as being black and white to kind of in terms of efficiency, but outside of the law within the healthcare sector specifically, I'm wondering if that approach within the process, but also within the ultimate determination, exacerbates already kind of practical inefficiency and resource issues within the healthcare sector.
So sorry, is your question that this kind of a process, the kind of process I'm advocating for, would be more resource intensive?
Right.
Yeah.
And how do you solve that? If
Yeah.
that's the case?
I mean, I can't. It's more resource intensive. Absolutely. And I think there are very valid questions about what that means. I mean, the degrees of intervention, I mean, really, we shouldn't be putting all our resources into crisis care. Crisis care, of course, is incredibly important, but what about all of the care that could come before it? All of that, the resource conversation is complicated. I mean, people talk about social determinants, you know, income supports, all those things that we know are very important for health as being expensive. And then there's all kinds of research that says, well, no, it pays for itself. And that actually is saving of resources. So I think that resource question is important, but can also be a red herring. If a reorganized healthcare system, I don't want to make light of the problem, and we have very, very overburdened health systems and healthcare professionals who don't have, you know, enough time or resources to do what they're tasked to do. So this is not at all a problem that I'm putting at their feet. But I mean, if we were to, as a society, try to reorganize our healthcare system and, you know, think big, this is maybe a little pie in the sky, but I think that's something we could do. And the resource question it's not so clear that providing more resources, for example, for prevention is indeed expensive. I don't know if that answers your question.
Yes, thank you.
So maybe to build on that, and I'll go further with some of the other questions. One of the things that I'm wondering, and I'm thinking loud here in my question, but is whether one of the problems is not that the approach taken increasingly is to see capacity as not just a necessary, but also as a sufficient component of deciding whether something should be provided or not. And that links to the fact that we do value in general in society autonomy and for decision making, and then autonomy gets collapsed into the capacity, and so a test has been made, so that is presumed to mean that the person decides something autonomously, but it ignores in the healthcare context that medicine is also a learned profession where there are certain standards to be met, certain decisions to be made about what's appropriate or not, and that I hear that from practitioners in the field that they are increasingly, even within the profession, pushed when certain treatments have to be provided, say in the context of providing medication for certain conditions where they are not sure whether this is the right approach to take, where colleagues say, well, but if the patient asks for it, it has to be provided. I mean, we're, in other words, the normal working of medicine where there is a kind of an interaction and capacity for decision making is an essential, but not necessarily sufficient component of deciding what's the good thing for the patient. So you see what I mean, where certainly in the medical aid and assistance in dying context, it's the same, but it's not just there. It's also in the context of, for example, overprescription problems, where individuals are pushed to ask physician for something, and physicians are increasingly told, well, if that's what the patient wants, that's what the patient wants.
Yeah, I mean, I've mostly been talking about the sort of side where people are perhaps deemed to lack capacity, but there is a strong argument, the same argument really applies for people found to have legal capacity. It's not because we meet this little test that all of our decisions are wonderfully autonomous. And I think, some of the literature on informed consent, I think is really strange. It talks about how, well, a physician offering advice is, is coercive because you're pushing the patient in a particular direction, and they should be able to make their decision free from those kinds of, and it's, to me, that's bizarre. Who, especially in a potentially scary medical environment, is able to make these decisions without input. And not to say that we want all of our information necessarily coming from a single healthcare provider, but that's an important standpoint. And so, yeah, this kind of idea that there's a continuum of autonomy that we need to support it throughout also certainly applies to everyone, even people who might have been deemed to have legal capacity. It's not independence. Capacity, autonomy is not independence.
Okay. Jane?
Yes. I think it was answered for the most part, but I guess another question is, I think that it's kind of undeniable that the relationship between medical professionals and patients is very much centered on sort of the social, economic, and cultural environment and the country that they resided in more generally. I think you mentioned even across our provinces in Canada, there's these differences of how we treat mental health law. So in what ways, I guess in a more operational perspective, does the relational autonomy approach actually account for these cultural sensitivities in the attitudes of how patients regard the relationship between themselves and their physician?
Yeah, that's really interesting and important. We know certainly that there are different medical cultures. I've been I spent some time in Greece, and I was really struck by how in Greece there is a culture of not questioning your doctor. Very, very different from here. And certainly every culture is going to have its own norms for that relationship. I don't know if I have a good answer for you, except that it's really important. It's not something I've investigated deeply. Yeah, how do we make those relationships meaningful and sufficiently empowering given, I mean, I suppose relational autonomy work there's been a lot of work looking at potentially disempowering relationships based on gender. So, you know, can a person who's socialized in an environment of gender equality still make autonomous decisions? So maybe there's an analogous comparison there that, you know, we need to be aware of the kind of overlay of cultural norms and how those norms also might be undermining authentic and autonomous decision-making. I don't know what the answer is, except to really be aware of the operating values and reflect on them. It's not a very good answer, but it's a really good question. Yeah. Oh, sorry. You could.
I think Sophie answered at the beginning that it's kind of outside the scope of this discussion, but I can still ask it.
Yeah, no, you know, ask you. I think it's fine, yeah.
Okay, so I was just wondering if you think that the definitions of like autonomy and legal capacity kind of change depending on the treatment that's in question. So say if it's like something that's just in the best interest of the individual in question versus if it's something like necessary to save one's life. Do you think that that has any bearing on these definitions that we're talking about?
I mean, I think it has a bearing on how people apply them. When there's a decision that is about treatment that's life-saving, for instance, I think people just kind of are more likely to budget a little bit, even, you know, if it's not the correct outcome. So we're more likely to, and maybe rightly so. I mean, maybe it's right when the risk, when the stakes are higher, to be more conservative and more risk averse in the application of standards. There are people who make those arguments that there maybe should be a sliding scale of capacity. We don't have that in Canadian law, but it is an argument that some people make very expressly. So we don't have that in law, but I think we arguably have that in practice. You know, along the same lines, there are lots of people who have observed there's the law and then there's how it's applied. There's a fairly significant law practice gap sometimes. So in mental health law, I think particularly, there tends to be an assumption that treatment refusal indicates incapacity. So there's an example, I think, where the kind of decision does influence the application of the standard in ways that are a little bit not lacking in transparency.
Mm-hmm. Yes.
I was hoping you could speak a little bit more about the relationship between determining capacity and relational autonomy. Do you see a need for modifying the way capacity is determined in order to better sort of fit the framework of relational autonomy, or sort of can it exist as it stands now? It's just the way that is then used within the framework changes.
I'm not sure. I'm sort of grappling with these questions myself as to what it all means in practice. And I will be the first to admit I haven't really drilled down in tremendous detail as to what this could look like. But I think I'm persuaded by scholars who talk about how really a meaningful assessment of capacity would take longer. And require more training. So there is a sense in which, yes, I think a real relational autonomy congruent approach would require changes to certainly the process. I also think that the standards would need to be changed somewhat. You know, one of the tricky parts of capacity law is the idea of appreciation. and it's sort of, it's like the kitchen sink can go in under appreciation. It's sort of, well, yeah, you understand, but we don't think you appreciate. And I don't, I'm not a clinician, so I don't want to speak too much about that reasoning, but certainly we see in court decisions and tribunal decisions that very often treatment refusal is treated as a lack of insight. So I mean, some people, including some people advocate for an approach to appreciation that's a little different, and I find this persuasive. The idea that it's not, we're not looking for some kind of objectively rationally defensible decision, but rather some kind of congruence, temporal congruence in the person's own life trajectory. So, does your decision fit within the overall arc of your life and your decisions and your values? And so that leaves room for a decision that might, for you to make a decision that's might not align with my values. Question a little bit.
Okay. Mm-hmm.
I was wondering if you could kind of touch a little further on the idea of children's capacity to, kind of make their own decisions. I see a lot of discourse online. I'm not a parent myself, but about like, my child doesn't want to get a vaccine and I want to teach her about consent and that it's her body, but at the same time, she needs to get the vaccine, and how that differs in children, such as those with cancer in childhood who kind of have a better understanding and knowledge of the system and then might refuse treatment.
So is your question, tell me again what your question is exactly.
I don't know that I know fully what my question is. I think just like, where do we draw the line in terms of like when like someone under, I guess, 16 can make those sorts of decisions without their parents?
Mm-hmm. I mean, so first of all, the decision-making rights of youth also are different across Canada. So in Ontario, there is no age cutoff. We apply kind of mature minor principle. Some places it is under 16, but there's a presumption that flips at age 16. I mean, I don't know. I don't know what the right answer is there. There's a ton. I'm not an expert on children and youth and decision making. There's a ton of literature there. But I mean, in principle, the same kind of concepts would apply. I mean, the same kind of framework in that we're looking to a person's degree of autonomy. I mean, I think the example of children is interesting because in the kind of discourse surrounding the CRPD, there is a strong kind of push for this idea of universal legal capacity, but there is always an exception there for children. I think even the fiercest advocates for universal agency still say, well, but not for children. And I do think that poses at least a conceptual puzzle. Like if we accept that diminished autonomy for children is relevant to your agency, then it's not only children who have diminished autonomy. So yeah, the same concepts are apply. How exactly they should be applied in the case of children with cancer, I haven't thought through.
Thank you so much.
So your suggestion was also, which I think you would agree with, is that experience of illness may mature. This is what you suggested.
Yeah.
So that children may become more mature by having to have dealt with disease and illness and injections. I mean, the example is often given that kids are known to get injections. I mean, they have more of a sense of what it means to get injections,
Yeah. Yeah, the trial and the agency is something that helps us to develop autonomy.
So there's some questions online, so I don't know if you know anything about this. Do you have any thoughts on the French institution Laborde and its unique model of autonomy promoting mental health care?
I don't know anything about it.
Yeah, so I would
I'll
suggest
look
to
it up.
the speaker or to the person who sent this at you that she sends you an email about this to get more information. Okay?
Yeah, I would love that.
And then the second question is, you could further explicate the support decision-making tools which BC has, what these look like, and your thoughts on these. On why these aren't getting applied to those impacted by or apprehended under the BC Mental Health Act.
Yeah, I mean, why they're not being applied. I am not on the, I don't have boots on the ground in BC. I've often wondered why BC is so polarized. And why there's a lot of really interesting, innovative work happening in BC around supported decision-making in not just it's called the Representation Agreement Act that sets out those tools, but also there's something called micro boards that are kind of little tiny not-for-profit incorporated entities that are created solely to support a person with a disability in using government resources and making decisions. There's just lots of interesting stuff happening. There's I think a strong presence of the organization plan. And yet, mental health law seems to be treated entirely differently. And I think advocates have been arguing for a really long time for that not to be the case. There's a lot of strong advocacy happening in the province. I don't know why there's so much resistance among lawmakers and seemingly in the courts to moving mental health law forward. I really hope this constitutional challenge that's currently before the courts changes things. I think it's a very strong case, and my former litigator, charter litigator hat tells me, this is a one that really has legs. So I hope that the law will be changing soon. But yeah, as to the mechanics or the politics behind that, I don't really know.
Any further questions, even for the students? I didn't take all the questions because some overlapped. I know that some of you had specific questions. I have a question. I don't want to put you on the spot.
Okay. Sorry.
So
I'll
the
try.
report on the medical assistant dying of the Parliament just came out, and early on in the report they have a sentence that, and they quote two McGill colleagues saying that the CRDP is in line with allowing advance requests for the provisions that you discussed, and the provision about this. So the CRDP is accepts or say the advance request for medical assistant dying is in line with the CRDP, period. So the idea being, you decide now in the future, I want to have something done to me, but you develop dementia, you don't know what's happening anymore with you. And it would become legal. That's what basically the report recommends, to provide medical assistant dying to people who are cognitively declined, who actually don't necessarily understand what's happening to them, but who in the past declared this. So we talked about this before. I would say, anyway, I would leave it up to you. Would you say it's clear that this is in line with the CRDP?
So I would think that it depends. If a person expresses a prior wish for medical assistance in dying, and then later is experiencing dementia or some, is in a different state and then rejecting that path, I think their later wish, under the convention, their later wish governs. I mean, there is I think a clear part of general comment number 1 from the CRPG committee that says they reject even springing power of attorneys, or any kind of advanced planning document that only comes into effect after a finding of incapacity, but there can be no finding of incapacity. So a later decision to say, well, I didn't mean that, I don't want this anymore, I think would, under the convention, would govern.
The later decision.
The later decision, because
these will be cases where there is no clear expression See,
I
that's
see.
that's
So
the
a
thing.
supported decision maker would be looking at their prior wishes as indicative of their current values.
Or it would even be, if this happens to me, this, so, I mean, the case I think I mentioned to you is a case in the Netherlands of a woman who had made an advanced request for medical assistance for euthanasia. And said even before, if I have to go to a nursing home or to a long-term care home, I don't do that. But, you know, she declines, but she's still quite fine. Family says, wouldn't you, we can't take care of you anymore, would you be fine in the elderly home? She's brought to the elderly home. And she says, oh, it's not too bad yet. You know, life is still fine to me. And things develop and the family and physicians continue asking, is it now? And she says, no, it's fine. And then suddenly at one point, she doesn't really understand the concept anymore. What this means. And the family and the physician suggests to the family, and family agrees to, this is the moment. But she doesn't interact anymore. And so they give her a sedative. And she falls asleep and they start the procedure. She wakes up and she tries to pull the needle. And the physician asks the family to keep her down. So this is written up, you know, this is not, I'm not inventing this. Family keeps her down and they end her life. I would say, for me, this is inconceivable under the CRDP that this would be in line with. So any expression of desire that leads to that where there has been no clarity about it would seem to kind of say, well, you're ignoring the person's present interest, you know? The person's present expression of interest, even if it's by movements, you know.
Yeah, I mean, certainly.
And even simply the idea of surreptitious medicating people is, in my view, against CRDP. But anyway, I'm interested what you think about that, like surreptitious medicating. In the mental health context, it happens all the time as well.
Yeah, I mean, that's a whole other topic, surreptitious medication, and I would agree is problematic. On your point about that example of the medical assistance in dying, I mean, yeah, I think it's pretty clear that certainly expressions don't have to be verbal, and we know that. There are all kinds of ways of expressing one's preferences. So I would think that if in a moment a person was using body language to say, I don't want this, then that would be being expression of will and preference. But I don't know what exactly.
The law does provide, to be clear, in the law, there is a statement that if something happens, that can be interpreted as a refusal, but has to be respected. But the question will be, how will that be done,
Yeah.
Because the law also says, the current law says, normal reactions to injection or to a procedure will not be considered to be refusals.
Right, is it just a
Which is like, well, what does that mean,
Yeah.
Do you do like this? Does this mean it's a normal reaction against anyway?
Hard question.
I just want to let you know, there's 2 more questions
Okay.
down, it looks like.
This doesn't work very well. Any jurisdictions where emotional and or considerations are being used in capacities of involuntary treatment? Not that I know of. I won't, I should repeat the question, I guess. Are there any jurisdictions where emotional and or relational considerations are currently being used in capacity assessments for involuntary medical treatment? So I can't pretend that I know the law in every jurisdiction. There may well be something out there. I don't know of one. The most concrete guidance that I've seen comes from the writing of Louis Charland, who does set out a pretty careful framework for how we might incorporate emotion into capacity law. So if that's an interesting subject matter for you, he would be a good person to read. I'll read the last question here.
So maybe to read it, I mean, I'll read
Yeah,
it,
do you wanna read it?
I'll read
Okay.
it out. So, because it's not visible probably. So the question is, the father received made and BC declared to his provider just before he died that he thought a lot about autonomy as if trying to please them. Two things. First, knowing him over 40 years, I know Dad's view of autonomy was a simple, positional, defiant, often reactionary, you're not the boss of me, and seemed to see suicide as a virtuous expression of his view, maybe for its own sake. Second, made is probably unique, and that is directly advocated as about autonomy or choice as well as dignity by clinicians, but these are concepts that are not clearly defined. What's the role of the patient, clinician's understanding of autonomy here? Challenging question.
Yeah, that's a very challenging question. That must have been a really difficult time. I mean, the clinician's view of autonomy, I don't really think should be the one that governs here. The clinician has to receive guidance from the law and from the patient on the kind of values they have that inform that legal definition of autonomy. I mean, it's a really, really tough area. That's the thing about capacity in any kind of legal test for agency, and that it's going to be imperfect. I mean, certainly a lot of the relational autonomy literature really talks about what makes us ideally autonomous. You know, ideally we should be reflecting on our values and, you know, engaging in deep introspection and considering to what extent those are authentic and how are the values among that are around us influencing us, and should we act in accordance with others' wishes or not, or when should we be defiant and when shouldn't we? But of course, none of us have those perfect skills. We're not perfectly autonomous. And so, you know, the law makes some kind of assessment. It takes some threshold and says, you know, we don't have to be perfectly autonomous, but is this person autonomous enough to make the decision? And, you know, in a situation like this, certainly it can be a bit heartbreaking. What would a relational autonomy approach say here? You know, perhaps that your father's values could have been investigated for the degree to which they were really authentically his, you know, but that's a tricky thing to express in law. I don't think I'm really answering your question here, except to say I'm sorry you went through that, and that's a really, these are really, really, really tough questions.
Mm-hmm. Any final thoughts, final question? Mm-hmm. No burning questions left. Okay. So please join me in thanking Sophie for a very good